Good afternoon, friends. My today topic is Section 107 of the Bharatiya Nagrik Suraksha Sanhita, in short BNSS 2023, which is going to be enforced from 1st July 2024. This Section 107 is a new provision in the BNSS and deals with attachment, forfeiture, and or restoration of property. What it says, I'm going into detail. First one is investigation. When a police officer conducting an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of criminal activity or from the commission of an offense, they may take action with the approval of the superintendent of police or commissioner of police. The officer can make an application to the court or the magistrate exercising jurisdiction over the offense. The purpose of this application is to seek the attachment of such property. So, under this section, while the officer is conducting any investigation, he comes across any property which seems to be obtained from the commission of offense. He is required to attach that property, but he himself can't do. So he had to take the approval of the SP or commissioner of police, and the application had to file to the court or magistrate exercising such jurisdiction. Then the procedure is notice and show cause. If the court or the magistrate has reason to believe either before or after taking evidence that the property in question is the proceeds of the crime, they may issue a notice as to why an order of attachment should not be made. This notice calls upon the concerned person to show cause within 14 days as to why an order of attachment should not be made. If the notice specifies any property held by another person on behalf of the accused, then that person must also be served a copy of the notice. So, when an application of attachment is before the magistrate or the court, then the court or the magistrate, if they believe that this might be or the proceeds are from crime, they will issue a notice. They may issue a notice. And the 14-day time is given to the accused. But if the property is held by another person on behalf of the accused, then that person has also to be served a copy of notice. Then comes the order of attachment. After considering the explanation provided in response to show cause notice and the available material facts, the court or magistrate may pass an order of attachment. This order applies to properties found to be the proceeds of crime only. If the accused fails to appear or represent their case within the specified 14 days, the court or magistrate may proceed to pass an ex parte order. Now, in between, there are interim measures. If the issuance of notice would defeat the purpose of attachment or seizure, the court or magistrate may pass the interim order. This interim order directs the attachment or seizure of the property and remain in force until a final order is passed. So sometimes there is a fear of the property being disposed of by the accused. So to avoid that, those things, they may issue interim order for attachment. Then comes the duties of the deputy commissioner, district magistrate. If the attacked or seized property are found to be proceeds of crime, the court or magistrate shall direct the district magistrate to ratably distribute these proceeds to affected persons. This formality or this duty has to be done within 16 days. Within 60 days, the district magistrate must carry out the distribution either personally or through authorized subordinate officer. So, this legal provision aims to ensure justice and accountability in cases involving property linked to criminal activities. Now, if the no one is claimant of the property, then this will become property of the government. This is all about what I want to say on this issue. Thanks for watching. God bless you all. See you again.